Welcome to Let's Talk Native with John Kane.
Seneca, I'm John Kane, and this is Let's Talk Native. I want to thank you for joining me. I've got a rather important issue that I need to talk about here. The Seneca Nation operates three gaming facilities in their Aboriginal territory, which is sometimes called Western New York. And these operate under the federal statute, which is the Indian Gaming Regulatory Act. And that federal law, requires that the native gaming operator has a gaming compact with the state. And the Seneca Nation New York State Gaming Compact is going to expire on December 9th of this year. So we're really close to the expiration of this thing. They've operated a gaming compact with the state, under a gaming compact with the state, for what will have been 21 years by the time December 9th rolls around. It was a 14-year term with a automatic 7-year renewal, and that was automatic if there wasn't a point of contention. And I'll talk a little bit about that more later. But so this compact is going to expire on December 9th. And there is no signs of any kind of agreement that's going to come to fruition before then. And it's virtually impossible at this stage of the game, it's virtually impossible for the state of New York and Seneca Nation to come to terms and go through the entire process of not just negotiating, but approvals. And I'll talk about what those approvals would have to be, and have that done by December 9th. So there is a major issue and major points of contention on what happens on December 10th. IGRA has been in place for almost 35 years. And in 35 years, there seems to be more questions than answers as it relates to what happens when a state becomes belligerent in its so-called good faith negotiations with a native gaming operator, especially one that's an existing facility, one that's been operating for 21 years. So what happens if the state refuses to negotiate in good faith? Where does that leave the gaming operations? You know, some question whether the expiration means that the casino has to close down. Well, and that's absurd to even suggest that. The casino doesn't need to shut down because the state won't negotiate in good faith. That's just not going to happen. But what does happen? So how does the system continue? There is a compact that's in place right now, and that compact, they could operate under the same terms of that compact. I'm going to talk a little bit about what that could look like. There's also the possibility that the Seneca Nation could say, look, to the Interior Department, the state is being belligerent. They won't negotiate in good faith. Let's work this out with the Interior Department rather than the state. You know, and there's some speculation that the Seneca Nation and or the Interior Department could sue the state. But that's not even true, because the state of Florida rejected a major provision in the Indian Gaming Regulatory Act that allowed a native gaming operator or would-be gaming operator to sue the state into forcing them into negotiating in good faith. And that got struck from IGRA. So that doesn't even exist anymore. And there has been no clearly defined, again, over 35 years now, and that challenge was at the beginning of this term of IGRA. So there's been no resolution on what really happens if a gaming compact for an existing facility expires. Where does that leave everything? So that's part of what I want to talk about. But first, let me explain why there will not be a new gaming compact in place in time for this expiration of December 9th. First off, you have to have a negotiation between the Seneca Nation and the state of New York. And that means with the Seneca Nation's negotiating team, which is empowered through the council and the Seneca Nation executive, to negotiate with the state executive, that being the governor. Now, previously, the governor had recused herself from the actual negotiation, but it's still part of the governor's office that does the negotiation. She recused herself because her husband represented one of the major competitors to the Seneca Nation's gaming operation. He was a principal in a company called Delaware North, which does gaming and hospitality and all kinds of things. So she had recused herself. Since that last attempt, and I'll talk about that attempt, the governor's husband, who was a former U.S. prosecutor, U.S. attorney, has left the employ of Delaware North. I haven't seen any evidence that suggests he still doesn't hold stock options and all kinds of other stuff. So I'm not sure it's a clean cut, but it may be. But this enables the governor to enter back into the fray on negotiating a compact. And the governor's relationship with the Seneca Nation is one that I'll expand upon too as I go forward. But so what's happened previously was the governor's office, her negotiating team, attempted to get the legislature, which has to approve a compact, but she attempted to get approval from the legislature before she had even had an agreement with the Seneca Nation. She tried to get a blank check pushed through the state Senate and the state Assembly, which would have said they would agree in advance to approve whatever compact she negotiated with the Seneca Nation. And they weren't even provided, these legislatures, both the Senate and the Assembly, they weren't even provided with any details of what was essentially called an agreement in principle, which really wasn't an agreement in principle. In fact, the governor claimed she couldn't tell them because it was a non-disclosure. Turns out she was lying. But so the state Senate had actually passed this, a bill that would have given the governor a blank check here. But the state Assembly said, wait a second here, we're starting to hear some things. And what we're hearing, we don't like. So the state legislature or state assembly wouldn't approve it. So and this was all being forced on the state legislature in the 11th hour, the last days of their session, which is now expired, and there won't be another legislative session until after until next year. It's not to say they can't be pulled into a special session, but that's unlikely as well. So they tried to get a blank check passed through. It went through half of the chamber, but not the other half. And then the Seneca people started catching wind on what some of these details of this agreement in principle were, and the Seneca people were pissed. To go back, the compact that is in place right now, in its 21st year, had a provision which involved revenue sharing. Now, revenue sharing is not a requirement in IGRA's requirement for a gaming compact. So it's not a necessary element in a gaming compact. Revenue sharing is about giving the state money. And in order for revenue sharing to be legal, the state has to give a concession to the native gaming operator that is both substantial and quantifiable. That's the Interior Department's requirement. And by substantial, it has to be actually be worth more than the revenue they receive. Why would that be? Well, it has to be in the best interest of the gaming operator to have this revenue sharing agreement. So they have to benefit in a way that is bigger than the revenue sharing they're doing. Otherwise, why do it? If it's just a wash, if it's a break even, why even do it? So that ends up being part of the numbers that need to be crunched. And so what the Senecas had agreed to, not knowing what the gaming revenue was really going to look like in advance. I mean, they negotiated this back in 2001 for the casinos that would open the following year. But what they agreed upon was they would give the state initially, 18% of the net slot drop, which is the gross gaming revenue of their slot machines. So that means the money minus the payout, the state would get 18% of that, and the Senecas would keep the 82%. The problem is, out of their 82%, they had to cover all of the costs of everything. Now, that was just that was only for 2 years. In the next 5 years, after that 2 year, the 18%, it would go up to 22%, again, of the gross gaming revenue. And then for the final 7 years of that initial 14-year term, it would be 25% of the net slot drop. So what played out was that 25% of the net slot drop and the smaller percentages leading up to it essentially equated to the state getting 50% of the net revenue. So when for essentially for every dollar the Senecas got, the state got. Now, I'm talking about net revenue. I'm talking about the revenue that the Seneca Nation received after the cost of operating the casinos. So it wasn't a very good deal. I mean, it was a terrible deal. So what could the state have possibly given up to get this incredibly lucrative high percentage, 50% or more of the gaming revenue of a native casino, when they are actually forbidden from taxing or imposing a fee on the on native gaming? So what could they have possibly given up? Did they give up full exclusivity across the state? No. All they gave up was in a 15 county area of Western New York. The state of New York agreed that they would not allow Class 3 gaming slot machines, Class 3 slot machines to operate in Western New York. Now, the problem with that is slot machines couldn't be operated in Western New York anyway, not Class 3 ones anyway. It was forbidden by state law. The state constitution, the Constitution of the state of New York forbids Class 3 gaming, or it did at the time. So the state didn't really give anything up. They couldn't do Class 3 slot machines in Western New York anyway until they changed their constitution. And they didn't do that until essentially towards the end of the first term of the they wouldn't get a casino operating with Class 3 slots until 2017. Now, as it would turn out, the first term of the initial compact would essentially, the first part of the term would expire in 14 years with an automatic renewal. But the language of the compact never suggested that there was payments beyond 14 years. It said 18% for 2 years, 22% for another 5 years, and 7% for the last 7 years of that 14-year term. There was nothing in the compact negotiated by the state of New York and all their high-priced attorneys and all of their politicians, whoever else was involved. There was nothing in there that suggested there was payment beyond 14 years. So the Seneca stopped paying at the end of 2016. They stopped paying, and as it would turn out, they would stop paying at the same time that the state's licensed casinos would come online. One of them in the same market, outside of what was considered this exclusivity zone. But the other thing that was happening, even running up to that, is the state expanded its Class 2 gaming facilities in racetracks. They essentially built casinos in the exclusivity zone, but they said, yeah, but they're Class 2, so we're not violating the terms of the compact, because our agreement in the compact said we wouldn't put Class 3 machines. Now, there was a lot of wordsmithing in there, and of course, the technology changed to the point where a Class 2 slot machine looks and plays almost the same as a Class 3 slot machine. So there was no question that during that 14-year period that the Seneca Nation was supposed to have exclusivity, they were supposed to have government-supported market protection, New York State was taking market share every step along the way. In fact, it had gotten to the point where the Senecas, prior to 2013, had stopped paying. They withheld $600 million. And that's what I was talking about earlier when I said that dispute got resolved or settled in 2013, where the Senecas kept $200 million of that and gave up $400 million to the state of New York. And they did that because the state was really pressing to resolve this conflict, because they were in the attempts at that point to change their constitution, which required 2 successive state legislatures to approve Class 3 gaming, and then a public referendum. So they were trying to get this issue settled with the Senecas and the Oneidas and the Mohawks prior to going to a public referendum. So this would not be hanging out there. Now, the Senecas said you had violated the terms, or at least the spirit of the agreement, by taking market share with your Class 2 slots. The only thing the Senecas got out of that deal was keeping the 200 million, and the state could no longer call those facilities casinos, and they could no longer call the games slot machines. So they just called them, electronic games, and they called them racinos instead of casinos. But by then, kind of the smoke was out of the bottle. Everybody, people knew that there were three facilities within the so-called exclusivity zone that were essentially slot parlors. Class 2 as they may be, they were still, slot parlors, and there was no question about that. 2017, the Senecas stopped paying, and the state's licensed casinos open up. The state says, "Oh no, you got to keep paying." And the Senecas then, no, we don't. There's no language in the compact. There's nothing in the agreement, in the contract that we entered into with you, that says we pay for the last 7 years of that 21-year deal. So the state pushes them into binding arbitration, where two of the judges are white. One of them is a native guy, and he is a former Interior Department employee. He played major roles in not only native gaming, but in the Interior Department, which is supposed to be the federal agency that oversees the enforcement and the regulatory systems built into the Indian Gaming Regulatory Act. So two of the two white guys basically said, well, we know the language isn't there, but it was supposed to be. And so they essentially change what was an agreement to pay for 14 years into an imposition where the Senecas were forced to pay for the final 7 years. And the Senecas tried to fight it. But they had agreed to binding arbitration. But the Seneca said, wait a second, now you two arbitrators, you two judges in this arbitration panel, you have essentially rewritten the compact. We got to send this back to the Interior Department. The Interior Department wouldn't look at it. The Interior Department would not address the conflict. In fact, what the Interior Department had suggested, well, we won't review the elements of a compact unless both parties ask us to. Well, that's a little bit like a victim of a crime saying, or the police telling the victims of a crime, well, we can't investigate the crime unless unless the person you're accusing of that crime agrees that we investigate. That's essentially, that's a good analogy right there. So even though the state was trying to screw the Senecas, and we're talking at this point what a number that is once again approaching almost $600 million. And while the Senecas were going through this process, and look, I don't think the Seneca Nation, and I certainly didn't expect the Interior Department was going to be this, white knight coming in, even though it's now headed by a native person, not so white, I guess, that this white knight was going to come in and solve this. But the issue was, would the Interior Department highlight the problems here and address them at some point? And they essentially said, well, we're gonna recommend a rule change because we think that it's not a level playing field with states, and so we're gonna recommend a rule change, which isn't gonna come until like next year sometime, after the Senecas have to get through this process with the state of New York because of their expired compact. But the Interior Department did nothing. But before the Senecas had exhausted all of their remedies, Kathy Hochul, the darling governor of New York, the Democrat, again, we're supposed to be, everybody's supposed to think, oh, the Republicans are the bad guys, not the Democrats. They're both bad. But Kathy Hochul, she literally freezes the accounts, the operating accounts of the Seneca Nation to force them to pay. Now, why did she do this? I mean, the likelihood the Senecas were going to pay ultimately anyway, but she was under the gun. She was trying to negotiate, a pass through a budget through the state legislature, and in that budget, she had every intention of giving the rich owner, the billionaire owner of the Buffalo Bills, almost $1 billion, over $800 million, to help him finance the building of a new stadium. And apparently, because he was threatening, or he and she, the Pagulas, they were threatening that they would move the team to a friendlier city if the state of New York didn't give them the money to build a new stadium. And it just so happens that the new stadium was going to be built in Kathy Hochul's hometown. So she was really trying to pressure to get this money from the Senecas, because as soon as she did get the money, and look, she froze the accounts, the Senecas had to basically tell employees and vendors, look, those checks we wrote, you're going to have to hold them for a few days because we're going through this issue with the state of New York. And, checks actually bounced. The Seneca Nation's payroll checks had actually bounced, some of them. So this happens essentially on a Friday. The Seneca Nation issues out these statements out to their employees and their vendors. Hold on to those checks until next week. We're going to get this resolved. And by resolved, they meant they were cutting a check for $560 million to the state of New York. So that's what they did. They bowed to this extortion, essentially. They were literally being held hostage to make these payments. Now, so how did Hochul do this? She actually used a law that is in place to force people who have been fined or have some sort of tort, some sort of payment that is due because of a lawsuit or like I said, a fine. That's what this law is in place for. This law says if the state of New York has levied a fine against an individual, they can freeze their accounts, not necessarily take the money out of the accounts, but they could freeze the accounts to force that person to pay. So she treated this so-called revenue sharing as if it was a fine that the state of New York had against the Seneca Nation. And so some Seneca Nation had no choice. They basically had to make the payment, knowing that they were probably going to make the payment anyway, because they had pretty much exhausted most of the Interior Department wasn't stepping up, and that was their last recourse. But then she takes that money and she turns around and gives out of that $560 million, she gives over $400 million of it to Terry and Kim Pegula for a new stadium. I mean, you can't make this stuff up. So billionaires looking after billionaires, and that's what it comes down to. So that's how that played out, and that's the foundation that exists that this so-called negotiation is being built upon, and it's not going well. So I got to kind of get back to the biggest point of contention with the negotiation, which has to do with revenue sharing. Again, not required by law, and not required to be a part of a gaming compact. It is something that you can add to a gaming compact if both parties agree. But let's be honest, the current term that we're operating under until December is no longer an agreement. Essentially, the third arbitrator, a gentleman by the name of Kevin Washburn, he basically said the two white guys, the other two guys on that arbitration panel, they rewrote the compact. That's why the Seneca Nation was saying, okay, Interior Department, you need to approve this change or look at this change because we don't agree to this. So for this last 7 years, the Senecas were being forced to pay revenue sharing. They never agreed upon it. They were being forced because of the agreement that they had with binding arbitration and the failure of any court to look at this thing, because all the courts kept saying is, hey, you agreed to binding arbitration. We can't even look at this thing. And since the Interior Department was playing this game that said, well, unless the state of New York asks us to look at this thing, we can't ask just if one party asks. So that's the mess that was created. Now, keep in mind, the Interior Department is supposed to enforce this agreement. And they did look into one aspect of the gaming compact, one that suggested was raised by some of the some influential Senecas and the Seneca Nation, that the state had become a third-party shareholder, essentially, of the gaming of Seneca Gaming, and which is prohibited by law. You cannot have these have to be operated or owned and operated. Now, they can have a management company, but these things have to be essentially owned by the Seneca Nation, or the nation that's operating these things. You can't bring in an investor that has equity in it. Nobody else is allowed to have equity. You could hire a company to do a job, but you can't give them equity in. There can't be any third-party ownership of a native casino. That's just the law. But what the Senecas were arguing, the definition of a third party shareholder is, do they have a long-term involvement? Well, a gaming compact that's sometimes 20 or even 30 years, yeah, that's a long term. Are they getting paid? Yes, New York State is getting paid handsomely. In fact, they're getting 50% of the net revenue. And do they have any say on the operation? Well, absolutely. I mean, the governor essentially has to approve any games, or the state has to approve any games that happen in a native casino. So they have um, regulatory authority, they have income, revenue generation, and they have long term involvement. That, by definition, that is essentially a third party operator. But when the National Indian Gaming Commission looked at it, it says, yeah, it's true. All those three measuring criteria, the state does cross that threshold, but it's all part of IGRA, so it's not really a violation. So, but in that investigation, NIGC did say it does appear that the Senecas overpaid, that they paid a much greater sum of money than the value of the so-called exclusivity. And again, let me go back and talk about that exclusivity. Keep in mind that to the extent that the state of New York could take market share from the Senecas, they did. And they did it in multiple ways. I've talked about racinos. There's no question that they built facilities that were put up to look and feel like a casino. And in fact, they even called them casinos in the beginning. And they advertised the machines as slot machines. Up and down the New York State Thruway, you saw all these advertisements. And they did it across the state, not just in the so-called exclusivity zone, but they did it across the state. But what else was the state of New York involved? Well, they've got lotteries all over the state. And they expand everything from simple scratch-offs to any quick draw. Some people call it crack draw because it's so addicting. And obviously, their big lotto. I mean, they've got all kinds of gaming associated with the New York State Lottery. They also approved sports betting, and sports betting. Initially, they said it was brick and mortar. It had to be, you had to go into a casino essentially, or a facility to place bets. Then they approved mobile sports betting. So now you had people in Western New York who could gamble essentially on their phones. They could place their bets. They could, call DraftKings or, any of these other, sports betting enterprises. And so every step along the way, the state was finding ways to grab gaming market share. Some of their old stuff like lotteries, their new stuff like these racinos/casinos. And of course, they ultimately changed their constitution so they could do Class 3 gaming. And then they placed one of the casinos right on the edge of the exclusivity zone. So clearly still in the market, the gaming market of the Senecas. Much of the advertisement isn't just Rochester. They're advertising in Buffalo and in Western New York. So this is what the state of New York has done. Now, technically, they may not have violated the exclusivity that was really geared towards only Class 3 slot machines. But by any means that they could grab market share, they diminished the value of that exclusivity because the whole exclusivity was supposed to protect market share. So if the state found workarounds to find other ways to grab market share, then it diminished the value. So when the NIGC says, well, they probably didn't get what they paid for, the fact of the matter is they never got exclusivity. The state, as I said before, couldn't do Class 3 slot machines through the entire 14 years initial term of the compact. They couldn't. I mean, they changed the constitution, I think, in 2013 or 2014, but it wouldn't be until 2017 that their first casino would open up. So that entire 14 years, the state couldn't do Class 3 slot machines by their own law, not by the compact, not by their exclusivity agreement and their revenue sharing agreement. So they got money for nothing. And even if you were trying to put a value on that exclusivity, you have to acknowledge that every means that the state had to grab market share, if it had any value, that value was being decreased. It was being diminished significantly. The Interior Department's National Indian Gaming Commission acknowledged that the Senecas probably overpaid, and the investigator said it probably warrants further investigation. But that was it. Out of that tension, again, the Interior Secretary, Deb Haaland, native person, who knows gaming because she was involved in gaming back in her nation, Laguna Pueblo. She knows gaming. She knows what revenue sharing is and the problems existing with it. The best she offered was a rule change, and that rule change was going to significantly change the leverage that states would have, to because look, it's prohibited that the states could force a revenue sharing agreement. That's against the law. It's also against the law if the value of the state's concession drops down too low compared to what they're getting. And that's what the Interior Department refused to ever investigate. They never monitor it. I think early on they knew there was a problem there, but they refused to do their job. And I don't mean just Deb Haaland. I mean, we're talking about Interior Departments back to 2002 I mean, that just they weren't going to address this. So it's a problem that has existed through multiple administrations, Republican and Democrat. So I mean, just to be clear. And again, the initial compact was negotiated with a Republican governor, George Pataki, and became contentious through most of the Cuomo administration, and ultimately with Kathy Hochul extorting the last over $500 million out of the Senecas so she could make her budget deal, her Bill Stadium deal. That's the way this thing is played out. So again, let me get back to what happens on December 10th. There are multiple scenarios and many of them have been put out there as a scare tactic. Some people are saying, "Wow, on December 10th, we've got an unlawful operating casino. If we continue to operate, we'd be breaking the law." Well, that's not entirely true. Now, they would be operating without an agreed upon, currently agreed upon gaming compact, but that doesn't mean that in the absence of the state's willingness to really come to the table, that the casino is somehow illegal. It's not an illegal gaming operation on December 10th when it was on December 9th, a legal operation. That's just not the way it works. There are several options. Obviously, the one option is they can rush through and agree upon a compact, and the state legislature would do a special session, but none of that's going to happen. And again, I have to get back to the fact is that the Seneca people are opposed to revenue sharing. What's a bit peculiar in all of this is that the Seneca Nation was opposed to revenue sharing in 2017. They stopped paying. They stopped sharing revenue in and they weren't just doing it because of a breach like they had done, prior to 2013. No, they weren't doing it because of a point of contention. They were saying, "Look, we're done. The terms of the compact said we paid for 14 years, and that's what we paid." And the Seneca Nation actually argued, but their exclusivity, which was kind of pointless at this point, was still in place because they had paid for 14 years. It was like they were suggesting they paid in advance. And maybe that's part of their justification for grossly overpaying for 14 years. So, but this was the Seneca Nation was arguing, no, we're not paying anymore. That was in 2017. This fight would go on for years and only get resolved like a year ago. So why was the Seneca Nation taking a position that they weren't going to make revenue sharing payments anymore since 2017, and now are fighting their own people over wanting to make revenue sharing payments? And frankly, the agreement that they had originally, the one that died in the state legislature, that the Seneca people never even got to weigh in on, would have had them paying essentially another $2 billion to the state of New York. It was going to be a 20-year deal with a 10-year renewal. It was going to be 30 years paying at 19.5% of the gross gaming revenue, which, as I said earlier, because of the cost of everything going up, and the Seneca Nation would have to cover its, all of the operating expenses out of its close to 80%. When all is said and done, the Senecas weren't going to end up with any more money than the state of New York was once again. And then the state comes back with an 18.5%, which is absurd. It's an absurd number. There is no value in the current exclusivity. And there are people that are arguing, yeah, but that exclusivity may only say Class 3, but it implies this. No, nothing is implied in a contract. And even if the state of New York makes certain stipulations about other potential gaming, if they can wordsmith what gaming they do include so it doesn't meet those specific definitions in that stipulation, they'll get away with it again. That's how they did it the first time. But here's the biggest thing. The state's competitors, including those so-called racinos and the casinos and there are new ones going up all the time. There are three more being built down in the New York City area, from what I understand, or will be built. But those state licensed casinos and racinos, they've got to pay 40% of their gross gaming revenue to the state of New York. They have to pay an even higher percentage. So if the Senecas don't pay that 25 or 22 or 18 or whatever the percentage is, if they don't pay the state of New York, they have a huge competitive advantage over the state licensed gaming operations. In fact, they have a huge competitive advantage over any kind of gaming for all intents and purposes, because they would finally be able to keep all of their revenue. So even if their revenue dropped off, I mean, honestly, even if the revenue dropped off by 50%, it would be a break even for them because they'd be keeping all of the revenue. So the Seneca Nation's strongest angle for competitive advantage is to keep all its revenue, not to pay for some absurd, bogus exclusivity that doesn't even apply anymore. Because again, let me be clear here. The industry is changing. Most gaming is now shifting away from massive world-class casinos being built. Yeah, maybe in New York City you're going to pull that off. But when the state approved a casino on the other side of Rochester called the Lago, that's been a failing enterprise since day one. They can't even pay back the money they borrowed. It's only been able to make interest payments because the market doesn't bear it. Not only because they're competing against a well-established gaming operations like the Senecas have, but the market is diminished. And a would-be gambler has sports betting. They've got lotteries. They've got scratch-offs. They've got, racino. They've got all kinds of stuff that they can do. They don't have to go into a world-class resort to where they give free drinks away and that kind of. No, they don't have to do that anymore. So it's become an increasingly saturated market and a diminishing market at the same time. Now, that's not to say the Seneca Nation's gaming operations aren't viable. They're absolutely viable. Frankly, they're viable even when they're being extorted for half of the revenue. But what makes them not just survivable, but thrivable is that they keep all the revenue. There is no number that the Senecas could pay to the state of New York and get something in kind that would be a net benefit for the gaming operations. So as I hear state or Seneca Nation officials tell their people, well, we need to secure our market. Well, secure it with a competitive advantage. And again, when I hear the Senecas, not just the Seneca officials, but their lawyers, their gaming experts, their casino executives, when I hear them trying to pitch the value in making revenue share payments, it doesn't reconcile with the fact that they were stopping payments in 2017. There's just something really wrong with the picture. Now, I know a lot of people are saying, well, it's because it's corruption. Somebody's getting paid off. I don't know that that's true. I think it's a failure of leadership because, look, they could get answers from the Interior Department. Maybe they can't get intervention from the Interior Department, but they should, by now, after 35 years of IGRA, someone should be able to answer the question, well, what happens when a gaming compact expires? Because here's my pitch. My pitch is continue under the terms that you agreed upon of the current compact, keeping in mind that you never agreed to keep paying for the last 7 years. So strike that. End revenue sharing. But keep the same reporting. There's some other points of contention about how the state tries to administer fees and that kind of stuff where they won't itemize the bills. And that can be resolved. And in fact, that point of contention, continues. So even if they operated under the exact same compact that they've operated for essentially 21 years, minus revenue sharing, because they didn't agree to it in the last term, it was imposed upon them by arbitration. And the Interior Department is acknowledging that there's something wrong in the equation between what the state's concession was and the revenue sharing that they get. So just continue. I mean, I heard one one of the Senecas, who's a lawyer, saying, "Well, the state would be happy to continue under the same compact because they get paid 25%." No, don't pay them 25%. Stop making the payments. And you know what? If you can delay negotiating and agreeing upon a new compact until these rule changes that Deb Haaland and the Interior Department are recommending, because if you make an agreement now, the rule change won't matter. And if somebody goes, "Oh, we can always go back and revisit." No, you can't. You couldn't even stop payment after 14 years when the compact called for no payment beyond 14 years. You couldn't get away with that because binding arbitration, look, rule of law doesn't apply to Native people. I've talked about, my good friend Peter DeRico's book, Federal Anti-Indian Law. And it's the entrapment of Native peoples through the legal process. That's what the book is about. And what he asserts is that they make stuff up as they go along when it comes to Native people. They don't use the Constitution. There's no constitutional foundation that gives Congress the power to pass laws like IGRA. They just do it anyway. There's no rule of law that establishes that we have somehow been legally subjugated by the United States. They use the doctrine of discovery and all of this absurd authoritarian rule when it comes to Native people. And we saw that even in arbitration, not just in the courts, not just in the state courts and the federal courts and the Supreme Court. We even saw it in arbitration. Those two white guys had to violate two significant basic principles. One of them is what they call the four corners doctrine of contract law. If it ain't in there, it ain't in there. You cannot suggest that a contract can be enforced based on what some people are implying should be in there. It has to be explicit, not implicit. It has to say it in there. It had to say the Senecas pay for 21 years, and it didn't. There's another significant part that this arbitration panel refused to acknowledge, which is considered among the canons of construction, which basically say that when it comes to treaties and contracts with Native people, if ambiguity is present in those agreements, the interpretation has to sway towards Native people. And so why is that? Well, part of that is, frankly, a little bit of racial bias. They think that we're not as sophisticated as white people, and that white people should know better. The government and anybody that we contract with, they should know better. They've got the higher priced lawyers. They've got PAC organizations. They make political contributions. They've got lobbying firms. They've got all kinds of stuff. So it should be on the state of New York to make sure that if they believe that payment was going to continue for another 7 years, then it should have been articulated. It should have been explicit in the agreement. And the canons of construction say, if there's ambiguity, you got to rule on the side of Native people. And that is a federal standard. And again, but when it comes to rulings in favor of Native people, we just don't get them. And when we do get them, they usually have some sort of other hidden agenda. The ICWA challenge, when people are saying, when this white family was trying to undermine and basically trash the Indian Child Welfare Act. The only reason it withstood the challenge was because the federal court says, well, Congress has ultimate authority on what happens in Native territory. Well, where did they get it from? I mean, they basically said when ICWA was passed by Congress to set up guardrails for the placement of Native children, they have that authority because it's in the Constitution. Well, it's not. It's not in the Constitution. There's no place in the Constitution that gave Congress plenary powers over Native people. But our own people will argue that because we are oftentimes so worried about the states, because the states, essentially have been more aggressive towards us for the most part than the feds have. But when push comes to shove, if our only defense against the states is to say, oh, our great white father in Washington, or fathers in Washington have our back. No, they don't. They don't. And they don't have the authority to even have our back unless we gave them explicit authority to rule over us. And then, of course, when they try to pull this, well, there's a federal trust responsibility. Peter DeRico addresses this in his book. He says, the so-called federal trust responsibility essentially throws trust law out the window because our best interests are not what's at stake in the so-called federal trust responsibility. The federal government's is. And they know it, they say it, and they are unabashed about the fact that now we don't really have a trust law issue with that federal responsibility. We just we just balance, the national interest with whatever interest we regard Native people to have. So I come back to this issue, and what I've got to say is the Seneca Nation does not necessarily have to give in to the state of New York, and they shouldn't. I mean, they should not even entertain the idea of continuing revenue sharing. In fact, they almost can't. The industry is changing, it's shifting. The best thing the Seneca Nation can do from a gaming standpoint is keep all its revenue and stop giving a lion's share or even an equal share to the state of New York. And you know what? Western New York, here's the way the so-called revenue sharing was supposed to work. Well, the way it was supposed to work is that the Senecas make these payments to the state of New York, and then 25% of what the state received would go back to the local municipalities where the casinos exist. So the city of Salamanca, the city of Buffalo, and the city of Niagara Falls. They would get 25% based on the revenue that came from those casinos in those localities. So the Seneca Nation could still do overtures to Buffalo and Niagara Falls and Salamanca. In fact, the Seneca Nation owns the real estate that the city of Salamanca resides on. So they should step up with Salamanca in a big way. Anyway, and it doesn't have to be a revenue sharing agreement. It doesn't even have to be tied to the casino. It could be the Seneca Nation having a program, a good neighbor program with these municipalities. Now, it might not look like the 25% of 25% or whatever it is, whatever it's been. It might not look that way. And it may not even be with the municipalities. It may be with major actors within, the shakers and movers in each one of those municipalities. So it would be more effective. It won't get lost in, it won't be filling in potholes. It would actually be building something up. The Seneca Nation could do that. They don't need a revenue sharing agreement to do that. But again, only 25% of what $2.2 billion went to the state of New York. Over $1 billion of it left Western New York. So when we want to talk about economic impact, and the Seneca Nation has done studies on it, and of course, it doesn't even make sense that they would be entertaining making revenue sharing payments again when they've withheld them in 2017, and when they made their case for why they wouldn't pay, not just the language of the compact, but the fact that the state of New York is the primary beneficiary of their gaming anyway. All of the revenue goes into New York eventually. The Seneca Nation doesn't have foreign investments. They aren't from another state or another country or another region. The Seneca Nation and the Seneca people, every dime that gets spent into a casino that comes to the Seneca Nation or into the operation for that matter, gets spent right back in Western New York. $1.3 billion worth of economic impact the Seneca casinos have per year, every year. That's the impact that the gaming has. That should have bought you an exclusivity all by itself. Tesla didn't provide that when they got $1 million or however many, all of the tax abatements and everything else. Nobody else generated that much economic impact. But so the Seneca Nation's got no business even offering revenue sharing. And there is the only exclusivity that they've had, most of it was just on paper. Here's the thing. If they don't have any exclusivity, and this is the argument that gets made, and this is what some of the scaremongers do. They say, well, if we don't make revenue sharing payments, they're going to put casinos in Western New York. No, they're not. Why do I know that? Well, here's the thing. It costs $500 million for a state license for a casino. So in order for a casino to be built in Western New York in the Seneca market, somebody would have to finance first the purchase of a gaming license for $500 million, and then they have to spend another $500 million, or maybe something scaled down less. Maybe they'll do, a Morton building or something cheap, build something on the cheap. But they might, in all likelihood, spend another half a billion. So they're going to spend $1 billion to build a casino, and then compete against the Seneca Nation, where their operating costs are not competitive. They're still going to have to pay 40% to the state of New York, 40% of the gross revenue, and the Senecas will be paying nothing. The Seneca's competitive advantage will stop a casino from ever coming. And again, that's just the math on head-to-head competition. It doesn't visit the issues with a diminishing market and the shifting, the saturation that already exists because of other types of gambling. So that's not going to happen. Well, here's the other thing. Well, they're going to turn their Class 2 facilities into Class 3. No, they're not going to do that either because, again, the Senecas have a competitive advantage. They're going to put machines in every convenience store like they do with their lottery. No, they're not going to do that because those convenience stores would have to buy a gaming license too. And if the Seneca Nation, after 21 years of gaining this gaming expertise, can't compete against a 7-Eleven with a slot machine in it, I mean, don't even suggest that to me. That's absurd. Del Lago, a well-financed, well-built casino on the edge of the Seneca market, can't compete with the Senecas. When the Senecas were paying, they couldn't compete. I mean, that's going to be given away in a fire sale here. They're trying to sell some of the racinos because they can't compete in the market. They can't compete against the Seneca Nation, but they're, again, keep in mind, the state of New York is cannibalizing their own gaming operations. In fact, they were prepared to have the Senecas build a casino in Rochester, which would have destroyed Del Lago, probably would have destroyed Batavia Downs, the racino, and definitely would have impacted Hamburg and Finger Lakes and the other racinos that are there because the Senecas would have had a bigger gaming footprint. Now, I'm not suggesting for a second the Senecas should have done that. Let Del Lago work out its problems, and maybe it'll get shuttered, and maybe at some point there could become a scenario where the Senecas would acquire Del Lago. I don't know. I can't imagine it because of the nature of the business. And look, today we don't even know what gaming is going to look like in 5 years, and 10 years, and 20 years, and then we're going to sign a 20-year deal with another 10-year renewal. We don't know what gaming is going to look like, and to have the audacity to suggest that the people in power today at the Seneca Nation and their lawyers and their consultants that they're going to know more now than the next generation is going to know. Because when you're talking 20 and 30 years, half the people who are involved in this process now will be dead by then. The Seneca people, the way I'm reading it, will not approve a gaming compact that involves paying another billion or two to the state of New York. They just won't do it. Now, they're going to be threatened. What the Seneca Nation officials are going to say, well, your annuities might end. You know what? The Senecas are getting like $600 a month. And I could be wrong. Maybe it's more than that. But they're not. Anybody who thinks the Senecas are all rich because they have casinos, the sole source of public finance for the Seneca Nation comes from gaming. Oh, yeah, I know they got a couple of gas stations and they have other residual income. But the primary sole source of income for the entire Seneca Nation to operate comes from gaming. They don't have taxes. They don't tax their people. They don't take away from their people to provide them services. No, they just provide services. So the vast majority of the money goes into service and to making those $600 a month payments because they make them to everybody. Even the children get it banked for them. So don't let look. There's going to be more Seneca revenue if they stop paying than if they don't stop. Than if they do pay and buy the so-called exclusivity. They've got no market protection with this exclusivity deal that they've currently had. They literally paid for 14 years for no reason whatsoever. The state couldn't compete against them, and yet they paid them as if they could. I mean, it's an absurd proposition. So my recommendation: let this thing expire. I mean, you don't have any choice anyway. It's going to expire anyway. And And if the state refuses to negotiate a compact without revenue sharing, then pick it up with the Interior Department. But have a keen eye on these rule changes and what the current administration is suggesting in terms of what revenue sharing should look like going forward. Don't rush to make a deal that is going to end up costing you another billion or $2. It's absurd, and it hurts. It doesn't just hurt the Seneca people. Frankly, it hurts all of Western New York. When that $1 billion left Western New York, it left the entire region. It went to Albany. It never came back. I mean, that's money that is sucked out of the economy. And shame on Buffalo and Niagara Falls and Salamanca for begging for their 25% as they watch 75% of that revenue just leave the area. That was good for nobody, except for a governor trying to balance their budget. And it's not even a lot of money to New York State. Addressing the money that was given up to this football stadium, that isn't for Western New York. I mean, yeah, it gets Kathy Hochul some brownie points from her hometown. That was money given to a billionaire who's already made a bunch of money on the increased value of the Buffalo Bills over the years. Now, I realize that that's the way the business works. But he was entitled to know public finance to make this happen. To the extent that he was going to put money up front, he's selling seats in advance. He didn't even have to dip into his own $1 billion coffers to cough up money. Now, of course, the thing is overrunning in expenses, and you watch. Don't let the state throw more money at this thing. Any cost overruns should be on the Pagulas. They made their money off the environment. They made billions off of fracking for gas and oil, and they've made plenty of money, off of the Bills, and this new stadium, it isn't even geared towards the common man. It's actually seats less, and will have more luxury suites for wealthy people. Everybody else will be watching these games and on their tablets in the parking lot or at home. The average person isn't even going to be able to afford to go to a Buffalo Bills game. And that's a whole nother issue. So anyway, let it expire. You don't have a choice anyway. It's going to expire. But stop paying and make it clear. Make it clear to the state of New York and make it clear to the Interior Department that you're not going to get a new gaming compact negotiated by the time that it expires. And they should be able to answer the question. I mean, if asked directly, there's no way that Deb Haaland or any of her underlings can avoid answering the question. Can't we just operate with the old compact minus the revenue sharing, since we never agreed to this current revenue sharing that we're doing now? I mean, I hate to say you got to go hat in hand to the Interior Department, but you can demand answers. This isn't about Mother May I. This is like, we are in a situation where the third or fourth largest employer in the state of New York is being threatened by the state of New York to a shutdown. I don't believe that's ever going to happen. I don't think it can happen. So that's my take on the deal. Feel free, as you listen to this podcast and as you watch the video on Facebook or wherever else, feel free to weigh in. Give me your thoughts. And if you think I'm wrong, then let's talk about it. I'm not Seneca. I can't go to the public meetings. I can't ask questions of key personnel, but you Senecas can. So let this information that I'm sharing here inform you, so you are better equipped to take on your own elected officials who, for whatever reason, seem to be doing this about face about revenue sharing. Like I said, they withheld revenue sharing in 2017. Why are they pitching it now that it's so necessary if they didn't think it was necessary then? That's the question. So I want to thank you for listening. I'm John Kane, and this is Let's Talk Native.